welcome to this very special edition of the Arizona Law Faculty Book Talk Series, which is co-sponsored today by the Daniel F. Cracchiolo Law Library and the Arizona Law International Trade and Business Law Program. I'm Teresa Miguel Stearns, Associate Dean and Director of the Daniel F. Cracchiolo Law Library. And this afternoon's book talk features Professor Nicolas Perrone, who is Professor of Economic Law and Director of the Center for Law, Regulation, and Sustainable Economics at the Universidad de Valparaiso in Chile. He will be discussing his new book, Investment Treaties and the Legal Imagination, How Foreign Investors Play by Their Own Rules. And as you can see, we, of course, have the book in our library collection here at the top of the table, in both print as well as in our ebook collection. Professor Perrone's main research interests are in international economic law, particularly in international investment law and policy. He is an affiliated professor at the Center for the Rule of Law in the Americas at Georgetown Law Center, and he's been a visiting professor at various universities throughout the Americas and Europe. Professor Perrone is a member of the editorial committee of the Yearbook on International Investment Law and Policy at Columbia University, the Business and Human Rights Journal, published by Cambridge University Press, and Just Kogan's A Critical Journey of Philosophy and Law and Politics, published by Springer. Our interlocutor today is Professor Sergio Puig, DeConcini Professor of Law and Director of the International Trade and Business Law Program here at Arizona Law. He is also co-editor-in-chief of the prestigious Journal of International Economic Law. Professor Puig is the co-founder and current vice president of TradeLab.org, an organization to facilitate assistance in international trade and investment law matters by law school clinics. Professor Puig recently authored At the Margins of Globalization, Indigenous Peoples and International Economic Law, a very impactful book for which we hosted a book talk a short while back. It was in conversation with Professor Jim Maya, and you can find a recording of that book talk on our YouTube channel. Professor Puig has also authored many articles in specialized law journals, book chapters, which you can access in our scholarship repository and his SSRN page. So please join me in congratulating Professor Perrone on the publication of his book and thanking both Professor Perrone and Professor Puig for joining us today.
Maybe I should start. Nico, welcome again to Arizona. It's such a pleasure to host you. For those who do not know, Nicolas is co-teaching with me public international law, and we decided to organize this to really have a discussion on his recent book. So why don't we start with that? And why don't you tell us a little bit what your book is about and what inspired you to write about this rather controversial topic that is international.
Thank you, Sergio. And let me say, really, it's an honor for me to be here, and thanks for having me. Great, and also thanks to the students, to the public international law students as well. That's great to see. And so I don't know how many people are familiar with investor state dispute settlement and international investment law, from the audience. So like very basically, maybe you have heard of NAFTA Chapter 11 claims. Investor state dispute settlement and investment treaty law is about a right that investors have if they are protected under investment treaties or investment chapters under free trade agreements to bring disputes before against states before arbitral tribunals, claiming that states have violated some of the standards of treatment that are included in those treaties. This can be subjective standards or relative standards related to discrimination, or they can be substantive and they relate to the protection of property, contractual rights, and other proprietary rights of investors. One thing that is very specific of this regime is that it's the only international legal mechanism that allows individuals to bring disputes against states without having to exhaust local remedies, which is quite unique. So human rights systems allow individuals to bring disputes. Sometimes they're screened. That's in the case of the Inter-American system, they're screened by the Inter-American Commission. And in the case of Europe, they're not screened, but they need to exhaust local remedies domestically. That means they need to reach in the UK, for instance, the UK Supreme Court. Investors don't need to do that. They can just sue states directly. So it's a very strong right, and the definition of the obligations that state capital investors in the investment treaties are quite vague sometimes. So it refers to indirect expropriation or fair and equitable treatment. So it could be interpreted in many different ways. So what I was very curious about this regime is how is it that we have the law we have, not just the treaty standards are there, but they're very vague, and it's more about how they will interpret. And as Jesua Salakis from lecture says, it's also got very sticky. So states are not so happy with it sometimes, but still very difficult for them.
You can explain why states are not so happy with it, right? What is the issue with it?
We're gonna get there.
Oh,
And so the question, there is a law at the moment that I think many people are finding controversial. So how is it that we got this? So for many years, people were looking, at states, how is it that states negotiated this treaty? But then it comes out that, that the formulas are very vague, and it's not very clear whether the state had in mind that the treaty should be interpreted this way. In fact, some states say, actually, we wanted treaties to be interpreted differently. So people look at states, it's not very clear how states wanted the treaty to evolve. Other people have looked at international organizations, maybe the World Bank. How is it that the World Bank wanted the system to operate? I still think, that you don't get like really good answers if you do that. So although we know that in public international law, states are the master, they are the one who signed the treaties, they are the one who negotiated treaties. I think what will happen in this regime is that the answer lies at a coalition of investors, financiers, bankers, and CEOs of firms, particularly oil firms in the 1950s and 60s, who got together, network, and discuss how do we want foreign investment to be treated, and how do we want it to be protected.
Let me just stop you. So to recap, so by states you mean the countries, right? Countries in some way have signed these treaties that give a right of action to investors. And then it's a very powerful right, right? That's what I'm understanding. And that is very, very much upsetting some of these countries because it's probably having an effect on them, right? They have to pay the awards that result from them. They have to go to an international tribunal, and they have to respond to this very upset investor who is saying, "Oh, you did this wrong when you took this regulatory action." And you're saying that what the key question is how this emerged, right? How this system emerged and became so sticky. And what you're saying is that, well, the states really didn't have much to do. It was this group of companies that link with other companies and international organizations to create something that was useful for them. But what's special about it? Because it seems to me that that's pretty much how the law works.
Fine, that could be something, we could get to it. I mean, that's certain. I don't want to say that states were not part of it. I mean, states signed the treaties and ratified it. It's like that, part of the conversation is like treaties are very vague. How is it that they have been interpreted this way? So what I found is that all the thinking, of these investors is exactly what has been translated into the law. So if you want to go back and see how is it that this, what's the origin of, the legitimate expectations, you can go back to the thinking of these people. So when you say, actually, there's no reference to legitimate expectations in the treaties, which is true, but they were talking about legitimate expectations in their treaties. So many of the developments that some people say like were unexpected, or some people talk even of a sort of an avalanche of imagination, actually, link back to the thinking of this. So for me, it's like this. So I mean, I guess this can perhaps resonate with an audience in the US. So now law and Lockean thinking is very important for property. You have Richard Epstein in NYU, all his thinking about property and how you should interpret the US Constitution goes back to Locke. So for me, there is something here. I mean, so these investors created something similar, a set of background ideas that either consciously or unconsciously we keep going back. So these ideas are not being discussed in a specific case because they conform what I call the legal imagination. So if you are a Lockean property thinker, no matter what the text as such says, you think about property in a particular way.
Okay, so let me stop here. Because we have to also put this in pitch this to a level where people can get, because it can get very, these questions of the human expectation, we can get there, but. So what is that Lockean view of property, and how is that different from, let's say, the property view of property that you may have in Argentina or Mexico in another place? What is exactly what that involves, right? What entails this view of property?
Well, this is what I call it. I mean, so through Lockean way of property, you're actually looking at how society is organized. So that's the idea of legal imagination, which I borrowed from Charles Taylor and what's his first name? Jeremy Purdy. That's as well in his book. So the idea is like this thinking about property is not just about how protecting private property or contractual rights. It's about how we want society to be organized. So these investors in the 50s were not only about protecting investment, they thought that foreign private investment should play a particular role. And for that role, to be possible, there had to be certain laws in place that would enable that. So when I use Lockean thinking, it's not because I say that investment law is Lockean thinking, but I think you can draw a parallel, because Lockean thinking is neither right or wrong, So historically, Jeremy Waldron has proved, I mean, that didn't happen. There was no state of nature or whatever. So, but it's very powerful. So it grabs people's imagination. So,
but I want to get back to this. So the idea of a Lockean view of society is something that's organized through market mechanisms. That's what I'm understanding, and property and well-defined property rights, right? Will that be correct? So, but that seems to be, a good idea.
So, and I mean, so the book is not claiming it's a bad, it's actually been very effective.
Yeah. Okay.
Rather than states don't like it, and many people find it controversial. And I think if we are concerned about the origin of the treaty text as such, formally speaking, of course, states signed the treaties. If we are concerned about who implemented, who kind of, was the sponsor of the Washington Convention that created the International Center for the Settlement of Investment Disputes, where you used to work, that were fine, that was World Bank and people working for the World Bank. But if you look at in the 1950s, the idea that individual states could sue investors could sue states directly was very, very challenging. So challenging and controversial that Germany signed the first BAT with Pakistan, but didn't include ISDS, although the people who were promoting this mechanism were kind of supporting it. So it was kind of controversial, and now it's the rule. And what is interesting? They said ISDS is going to be great because investment law, the standards in the treaties are vague and ambiguous. So ISDS is going to work as it would allow sort of the common law of investors to come out. It's not so the law. We're just giving very basic ideas, and the law is going to be developed by arbitrators. They were saying this in the 1950s, and they expected these arbitrators to interpret it in the way they were already saying. So this is how we think they should be interpreted.
Okay, so let me just recap. So part of the problem that you see, so you're trying to understand how this system became so sticky, right, in some way, and so powerful in many ways. And we can talk a little bit about what is the main concern by the countries, by the states. But basically, what you're saying, a big deal of this is that this creates some rights and defines these rights, right, in very broad ways, and then gives authority to these people to decide these questions, right, to these so-called arbitrators. And we may have one or two in this room. I don't know. But that it still seems to be very reasonable, right? Why, you are not going to create very fixed rules because these questions are controversial. So you need something that gives some kind of authority to a group of people that may be better and be able to define these questions. But I can sense a dissatisfaction with that delegation. So what is the problem then if you give this to this group of people, or what do you see as the problem?
Well, I mean, so it depends. So if you like, as I say, I find that there is a connection between this quote unquote legal imagination and a particular war-making project. So if you read the way these investors thought the war was going to be organized, they said it's critical for development that we have private foreign investments. That's critical. Now, and so at that time in the 1950s, there was a sort of a struggle or a discussion between whether we should have more aid. So Latin America was asking the US to, provide more aid. And the US was saying, no, actually, you should, make the right reforms and attract foreign investment. So these investors were on that, on that side of the island. That's kind of clear. And the other thing, so oil firms were very relevant back then. And now this needs to be contextualized. In the 1950s and 60s, during decolonization, many countries in what is now normally called the global south, back then the third world, they wanted to get control over the natural resources.
Okay. So let me then, so what I understand in this is part of the problem here is that this system replace the public involvement, right? The state or international organizations that were financing through state-sponsored initiatives with a mechanism of private investment. Right now, it's the companies like the big oil companies, the big infrastructure companies, the one investing in these countries, and that is displacing from this organization of the state very relevant articles, right?
Not or legal principle.
Like
the eminent domain.
Like eminent domain. So what do you mean by displacing legal?
Yeah, so eminent domain is a good example. So the chief counsel of Shell, his goal was that you would not have an eminent domain rule under international law. So that is that countries were not allowed to expropriate, even if they wanted. So you say, I expropriate and I pay compensation, market price. He, as the chief counsel of Shell, so Henry Shockley, was trying to make international law to ensure that countries could not do that. So if you got into a concession agreement and the concession agreement said, I'm not going to expropriate, that would be enforced under international law. So this is impossible in the US, for instance.
Okay, so
and this is interesting. So the American Bar Association was pretty much involved with this project, and it said that this is impossible because we have the US Constitution, and the US Constitution gives the US the right of eminent domain. We cannot outlaw this under international law. So just to be clear, international investment law is not like this. States can expropriate and they have to pay compensation. So sometimes these investors were very involved, but if you read some of the work, so this document of the American Bar Association is very interesting. They will say part of the project is to ensure that certain principles of public law that are enforced in Britain, in France, are not going to be applicable under international investment law because investors need more certainty. And these principles of public law could be problematic.
Okay, so now I see what you're saying. So these treaties and contractual provisions in concession agreements will display fundamental principles of property law or public law in different countries. And by doing so, big, large companies will have an advantage, perhaps, right, when they have to negotiate, or they will have a much more security in their investment. Now, but someone with a strong view of property rights will continue pushing, well, maybe that's not too bad, right? But you seem to also say that, well, the problem is that this has been taken to a different level by creating these very vague notions of what is the limitation.
Yeah. So that's a very good question. What's somebody who is a very, very strong advocate of property rights protection, particularly private property rights, no? So I think it's somebody like Richard Epstein would say, like, property rights, that the right to have property is so important that everybody should have the same right to property. But it's not like that in international investment, though, because we are not all foreign investors. So local communities, like indigenous people, don't have the same level of protection.
Corporations are people.
Yeah, but I mean, not everybody is a corporation. So some people are corporations, but not all people are. So you could say it creates certain disadvantage at that level. So there are like you can have a first quality property rights and second quality property rights. So I think that somebody who's a strong advocate of property rights, like Richard Epstein, just I really like his work, although I sometimes disagree with him. That's why I think it's relevant here. Just that I think he would disagree with that. So for a strong, the idea of a strong property protection, if it is for the dignity of the individual, if it's about how we want to organize society, I think it doesn't work. It works here, and it only works here if we say that we need to give foreign investors a privilege because we think they're so relevant to our society. They are so important that we need to treat them better. Now, I think this is problematic, and that's a sort of a question of economics, and but I don't think actually there is enough evidence to have that. So we have a system that is giving strong rights, but it's not necessarily paying off. Is it paying off? That's a question to ask the states. Are you getting a benefit? Because the economic evidence shows that by signing investment treaties, you don't attract more foreign investment.
So, you get into the questions of policy, but let's just the book is more about the history of the making of the system, no? And let's take you back. So, what is the thing that you uncover in the book, right? The main thing that you uncover that you think that wasn't discussed or that wasn't discussed enough. And it seems to me that it's part of how these different groups basically mobilize in a very important period of time, right? When things are changing about this is a post-war world where we are debating what kind of societies we are revealed after the law, especially in this part of the world, especially the West. So what is that key part that you felt?
Sure. Let me have a couple of pictures here. Let me show you all that. So we can like put some
Are you sharing screen?
no, it's good. It's just for the people here.
Yeah, okay. I can do it here. No? Oh, I don't think.
No, it's not because it's not connected, but I don't think it's necessarily Teresa. I mean, so the idea basically is that those of you who know the way public international law works, it's like state signing treaties, But of course, there are always, people are demanding certain, and the investment treaties in a way are the outcome of investors asking states that we need more protection at a time of decolonization, in which states from the south wanted to get control over the natural resources. So the picture that you have on your right, that's the gentleman who's smiling. He's just getting to Downing Street, the one like in the middle of the picture. He's Harley Shocker. So he was the British prosecutor in Nuremberg, and he was also, this is in the early 1950s, he was already the chief counsel of Shell. And he was going to Downing Street to discuss the nationalization of oil in Iraq. And he was very interested in that as a British lawyer who was in the oil business. So he realized, what's the problem? We are being, our important assets in Iran are being nationalized. This is going to the ICJ eventually, and the ICJ has no jurisdiction. There's no legal mechanism to protect our rights. So he gets a bunch of lawyers. How are we going to do this? The gentleman on the left, his name is Herman Abs. He was director of Deutsche Bank. He was a banker already during the Third Reich. He was also, and then he's one of the very few who kind of, repackaged himself, and then he was an advisor of Konrad Adenauer. He was, he's speaking there at the International Institute for Development Conference, a conference that was held back then every 4 years in San Francisco, suggesting that the world should have, sorry.
But we had a request on Zoom to see the photo.
Oh, no. Okay. So yeah. Maybe we can use the camera.
Yeah.
I'll just share screen, but keep going.
Oh, yeah.
Okay, so he was presenting this idea of having a Magna Carta, and this is sort of not that different from the treaty that Germany and Pakistan signed in 1950 on the first one. So eventually, Shokros and Abs got together, and they did what is known as the Abs-Shokros draft. And the draft, as such, is relevant to some extent. I think what is relevant is that they created associations like the International Association for the Promotion and Protection of Foreign Investment, and they were having meetings, they were lobbying governments, they were like lobbying the OECD, and they were having conversations with the International Chamber of Commerce, which has also been interested in this topic. And they got very close to the American Bar Association. In fact, the American Bar Association has documents where it says that it was one of the main promoters of the ICSID convention at the World Bank. So all these people were gathered in different places, and there are like records, Geneva, Vienna. They were coming here and meeting, with Eugene Black and other presidents of the World Bank. And these were the interests they were putting forward, the interest mainly of oil corporations. So particularly Shell had a very strong role in this moment because they were concerned about protecting those rights. So it makes sense. So of course, if I worked for Shell, I would have done that. Now, treaties are very vague and ambiguous. And if you look at the documents they wrote back then, they have been interpreted pretty much in the same way. That's why I find it fascinating. So it's like either they could foresee what arbitrators were going to do in the 90s, or there is some kind of relationship.
Right.
So I'm not claiming there is a causal relationship, but rather that they set up the scene, they set up the terms of the conversation, they define the agenda. So they said rights for investors, no obligations for investors. That's kind of the way it should be organized.
So maybe you want to show the other one so we can.
No, that's for another question.
Okay, comes up.
Should I stop here?
Yeah, I think maybe. So let me just get, because I also want to open this to other questions. Some people may have questions in the room, and maybe also we should respond some of the arbitrators in the room if they wish to make any point. But it seems to me also that part of the success of the system is that it's very nimble, right? In a way, it doesn't define very specific what rights are protected, but it defines in a broad terms. What it creates is a right of action. So if you want to bring some of them, because we can debate whether this is a good thing or a bad thing, but what really we see is a world that has changed, and a world where very few corporations are accountable in the ways that we wish they would be accountable. And you just talk about no obligations for companies. Companies cannot be accountable under international law, very limited. But if you want to bring a key insight about the system and its success to our new world, where we would like to see a different world where not only states are accountable for their mistreatment of the poor oil companies that were abused according to them, right? But in these days, so what would be that key insight that you think the book brings?
Yeah, so that's a very good point. So the book is pretty much about how the system is the way it is. And there is, as you said, yeah, I'm not a big fan of the regime. So you could say there is certain criticism, but the main thing is like how is it, because normally you would expect that it's resilient. If you look at for instance, how the trade system has evolved, then people go back to the negotiations of the GATT. They don't go back to documents of firms. But I think if you go back to documents of firms, and there's people that are doing more and more research on Shell, it sheds a lot of light on the regime we have today. So the trade regime was shaped by states and maybe USTR, the State Department. But it's interesting that when it comes to investment, it's not so obvious. And I think that firms had a very important role. I'm not saying that they crafted pretty much what we have today. Just saying they have a very significant role. So what does this tell us for today? I mean, I think that foreign investment operations are very complicated transactions. They involve states, they involve investors, but they involve the local community. They involve sometimes, banks, they work differently, they involve different institutions. But we have a regime that was imagined by one of these actors only, and only provides rights for them. And it doesn't even have, this is very interesting. If you look at the Sustainable Development Goals, investment is key to reach those goals. It's more, if you read the sort of the documents, it's more foreign investment or investment in general, it's more important than trade. Still, for trade, we have an international organization. State delegates are meeting there on a regular basis for some of the committees like the STS and the TBT committee. We have nothing comparable when it comes to investment. No international organization, no diplomacy. It's just a very quote unquote rudimentary system to resolve this because it's ad hoc, you don't have an appellate body or an appellate mechanism. So shouldn't we have something for investment that is really, that gives it for investment the importance it deserves to reach sustainable development goals?
So what I hear you saying is that if we will recreate a system in the future, we need something that balances who participates in the input, right? In the creation or recreation of the system.
Yeah.
Right. So in a way that for the future, right? Because the system is still very,
And probably will
remain. Yeah, it will remain. It's a more balanced. But maybe other people want to ask something. So let's open it, David.
Just a historical note, at least in the US, during some of the formative years of what became investment treaty policies in the US, I would say the late 60s and the early 70s, drawing a distinction between the bar and the government, I think is misleading because members of the bar were the government. And I think of the State Department and its legal advisor's office and its key officials during that period. Cecil Hunt, who was the general counsel of Texaco, was a major advisor. Stephen Schwebel, Karl Maw, your friend Charlie Brower was acting legal advisor for a year. So the policy formation that was going on was obviously affected by outside groups of the American Bar Association or these council, but the legal advisor, State Department usually had the ear of the Secretary of State. The Secretary of State under the US system has primary responsibility for dealing with these issues. So there was a significant group of very smart people, most of whom believe property rights are human rights, including the property rights of companies and their shareholders. And I think that affected the way the law was formulated, at least in the US. And since the US has a lot of influence, it probably spilled off. I mean, the US doesn't start doing BITs until when? 1980. We were late. But of course, in the 80s, lots of them. In the 90s, you had many investment treaties with many free trade agreements with investment provisions. So I think it's important, at least in the US and probably in the UK as well, and maybe not in a lot of other countries. The intersection of the bar, the investment bar, as really being a big part of the government.
So any other questions? I mean, yes.
I'm curious what your thoughts are on the role of coercion among states, because they're not all autonomous and they're not all equal. And I'm thinking about the case of Mexico, which had the National Financial Investment Committee in '73, and then after the bankruptcy of '82, it elaborated, it opened it up. And so this is more about, well, states exist in different relationships to each other. And how does that affect your story about coalition?
Any other questions? Oh,
Yeah, my question is about your discussion of the institutionalization of investment treaty. You referenced the WTO system has its own appellate body, has its own system mechanism that's rather advanced. Well, as we all know, it's in a coma. So the question would be, if you feel that future reform in the ISDS system can find success through the work of like Unsubstantial Work Group 3, through the creation of an appellate body, or is it better focused through regionalism, more successful through regionalism, such as like through European BITs and attempts to create localized investment courts?
Thanks. That's a great question. Yeah, good. Thanks.
Yeah, so
Thanks for the comment, David. It's very good, very good. Because actually, this is part of the conversation in the historiography. So one of the things is like, so it's unfortunately, and I say unfortunately because I think you are like touching on a very significant point. Unfortunately, the way the conversation was set up, it was like private investors were not very relevant. Like people like Shawcross, who was a very important labor politician in the UK, the prosecutor in the Nuremberg Tribunal, so somebody with an important standing in society, and also working for Shell. And you say yes. So Emilio Collado as well. He was working for the US, I think it was the State Department or something, and then he was working for Exxon. So many of these people were like moving from one place to the other, and sometimes like drawing a very clear line is not the right thing. And perhaps then the problem is that one of the concerns that many people have about international economic law is that these laws have been made pretty much hearing the corporate sector because they had an input or they had an influence over, the State Department or the Foreign Office in the UK, but other actors didn't have that. And now we have the regime we have. And then there comes the tension, because the local communities don't have the role they would like to have. Some states don't have the role they would like to have, and then we see this disparity. But having said that, the US had all these people. I mean, Schwebel was key, he was in part of these committees discussing. I mean, he was putting forward the idea of legitimate expectations, the way it's interpreted today, and he was key in the vote for the General Assembly resolution of permanent sovereignty on natural resources. And he kind of advanced the position that kind of prevailed, which wasn't very clear how compensation would work, but it would be under international law. That was his main goal there. And he kind of wrote a very short essay afterwards saying, like, we won. Now, the Global South is saying, oh, look at this resolution. Like he was saying, we won. So very interesting. I think it's critical. The only thing is that the US was not at the vanguard of promoting this treaty. It was European countries. And I guess that's interesting for what role the US was playing. It was like, trying to balance the global south of the third world would get tempted to go to the other side of the political spectrum. And that was, at least that's what you read in the historiography. That was a reason not to push too hard on that.
But they were very active in the UN with Resolution 1803, surge, all of the efforts by the South to limit the influence of international law and to make national law dominant.
Yes.
So hard to know who won that battle.
Well, no, I think they did. I mean, and this goes back to the question of coercion. So Mexico was, after the nationalizations of oil, Mexico was very conscious about this problem, because we had all these issues about compensation with the US, and it was complicated. And eventually, so Mexico was at the negotiation of the International Trade Organization in Havana, very strongly, was trying to get a position that was more favorable to what he thought the way it should be worked, and domestic law should be playing a crucial role. And eventually, it was Mexico that proposed the idea of the Charter of Economic Rights and Social.
But that also goes to a point, no? I think there was Latin American, as far as I know this story, right, from the exit perspective, they knew that there was an imbalance of power between the US and the Latin American countries, and then there's history that was very much in their part, and they organized to reject the initial proposal of having this convention, right? The Node Tokyo, right? This is back in the 60s. But you're right that then the oil crisis in the 70s changes the balance, and you get to the 80s where you start seeing the first deflectors, right? And the first deflectors start happening like that because there is particular ways in which the US manipulate this new reality to start negotiating bilaterally with states. No, I think it was Uruguay first, and then follows by Argentina, maybe and there is another Chile changes its law, right, domestic law, and eventually Mexico as well with the NAFTA, which agrees with this. But I do think that the way in which also the consensus existed, at least in some regions in Latin America, that we're a bloc, and the way in which that bloc got fractured by different, play a big role in the development of the system.
Yeah, probably. Is that something that you? Let's go back to the point of the 70s. So Mexico kept saying that we should have a different regime. So in the negotiation of the Organization of American States, it will say we should have a different regime. National law should be more significant, particularly for calculating compensation. And this position was taken to the UN in the 1970s. So Castañeda, Jorge Castañeda, the very famous Mexican lawyer, was, kind of the chairman of the working group for the Charter of Economic Rights and Obligation on Duties of States. And that position, I mean, got the support of most of the third world, but all the developed countries, capital exporters voted against. And Charles Brower was very actively saying that this is crazy. And John Blair, who was working for Shell, and he used to work to be sort of the deputy of Harley Shockers, was saying pretty much the same thing. And it was not just that SERS was defeated because of the votes, it's that I think many people created the idea that this is wrong. You know, international, this is wrong international law. It's not even international law, it's just ideas that have been voted down, and that's it. And that, for me, that moment is very important because that kind of signals that there was a project, a competing, I call it in the book, a competing imagination that was defeated. And it was defeated during the 70s. And I think, yeah, US lawyers play a very important role in that defeat. And eventually after that, you have the US BAT treaty program, the first one. So the two things are connected. And the reasons then why Latin America got fragmented, I think, are very complex. I'm like, yeah, it's like there are different variables. We could even consider whether Latin America was united at the very first, because it's not also true. I mean, if you look at what was happening in the 50s and 60s, some Latin American countries were more bold about the importance of domestic law. Others were less. So Brazil was less, and that's why Brazil was a key country, you know, in the sort of Alliance for Progress, and Kubitschek brought to Eisenhower, and all of this. So yeah, sorry.
Well, no, that's good. I would just point out that Mexico totally changed its position in the NAFTA negotiations under Salinas. It's only just because at that point they essentially gave up on the Calvo Clause, the requirements of national law. And it was not just Canada and the US forcing their views on Mexico. Mexico thought they needed the investment so badly they were willing to give investors that protection. And I think if you look at the number of investment claims that have been filed, it's skyrocketed after NAFTA, a few years after NAFTA, and it really hasn't slowed down until a year or two.
So what about
Yes, now that's a very good question. So if somebody could criticize the book as it doesn't provide a solution, okay, fine, there is no solution in it. But I do think that part of the idea is that how we would like, you know, so Jennifer Nadelsky, you know, from, I think she's in Toronto, isn't she? But she's in Canada. So when she's talking about properties, like we should imagine property law as how we would like, you know, to be organized, how we relate with each other. I mean, I think that should be the starting point. Because foreign private investment is very important for development. I think we need to treat it carefully in both ways. We need to ensure that it's going to be capital flowing around the world, you know, to build infrastructure and to promote development, generally speaking. But on the other hand, we want that to be sustainable development. We want that to, you know, be good for people. If it's just good for the firm that is making money, it's not worth it. I mean, at the institutional level, it's good for that CEO, perhaps, but it's not for institutionally. So the way we're thinking the law, we need to bring those considerations into the law. Now, that's why I rather see that perhaps will be sort of the starting point, you know. So the World Trade Organization, if you read the preamble, is like the goal is sustainable development, and we have all the states getting together, and there is idea that it's not just states suing other states. We need to know a lot of diplomatic activity. We need to have, you know, negotiation rounds. I'm not saying that the WTO is perfect. In fact, it has a lot of problems today. But I think at least in terms of how it was imagined, the chances that the WTO was going to deliver were higher than ISDS. You see what I mean? Because all the countries are represented and they are meeting. So it's not, I mean, imagine if you have a country governed only by judges deciding questions. You also need a mechanism that keeps, you know, adjusting the law. Maybe you need to launch a negotiation, a round of negotiations. You have like Ancestral Working Group 3, but it's only covering a couple of matters that are of interest of the European Union. I mean, if there was such a thing as a WTO for investment, then I guess Brazil would also bring issues to the agenda, or Chile would bring issues to the agenda, or Mexico. And maybe they lose, but at least they have a place where to discuss these questions. At the moment, they don't have such a thing. So this kind of, I think, is this bit of bitterness, like there's something going on, you cannot control it that much, it's kind of, yeah, I don't know what's your experience as arbitrators, I mean, but yeah, I got the sense from the side of the state that sometimes say, how is it possible that they decided in this case in this way? Remember Canada, when Bear Creek was decided, they couldn't believe it.
Which case?
Bear Creek, Bear Creek in Canada, Bear Creek, sorry, Clayt, Pilgrim, Canada.
Oh, but that's very specific, so maybe probably most people don't have a context to assess that question. Maybe we can leave the conversation with one last question, unless anybody wants to ask another question. So there's two more, so Andrew.
You both alluded to the stickiness this regime in the face of state dissatisfaction. Can you talk a little bit more about the reasons for that?
Yeah, that's a very good question. Yes. So some of the treaties that were signed in the 90s were very vague and they're very short. I mean, like there's not much detail in there. So in the 2000s, UNCTAD, like an international organization, and US as well, they started to add more detail into their treaties. We don't want arbitrators to decide in this way. So we add, this is how you should interpret indirect expropriation. So basically, US imported the Penn Central criteria into the US treaties. And then, well, maybe we need some exceptions, like in the GATT, some basis for states to justify their measures. And so we kind of incorporate general exceptions, like bringing or importing from trade law. But what happening with the very few cases that have been decided under the new rule, that the outcome is pretty much the same. So what is sticky, and that's what I mean, that there is what I call a legal imagination, and some people might call it a legal culture, certain background ideas on how this system should operate, and those are very difficult to change. Because in every single arbitration, those are not being discussed. But people bring arguments to win cases. And if states wanted to discuss those background assumptions, they might lose, because the tribunal doesn't want to hear that kind of conversation. So at the level of the system, because the system is actually, or this regime is actually what the law is, and the law is what the arbitrators say the law is. So this is what kind of reproduces the stickiness. Now, going back to the 1950s, they knew it. They said, we want this to operate like a common law regime, and arbitration is what's going to give that mechanism. So we don't care that much about being precise in the treaties. We care about having the right system to develop the law. And I think it worked out. So that's the sort of reasoning behind the stickiness.
I would agree with part of what you said. I will also add, maybe in response to this, is that has a lot to do with who decides these cases, right? And what are their backgrounds, where they go to school, what kind of ideas they think, right? And then if you have corporate lawyers from fancy law firms, maybe they will be more inclined to find these concepts readily available and decide in one way. And I do think that you pointed to something, right? That maybe there is some of the assumptions. But also what makes the system very sticky, and I would say, is it created its own political economy. And what do I mean by that? That now the law firms have an interest in representing clients who have this. Arbitrators have an interest of sitting in these cases because they potentially can have a lot of income by deciding these cases. Then there is like a lot of academicians that we have, thank God, a job because we can talk about this. Otherwise, we have a massive interest. So it became, in a way, very successful because its stickiness is not only its legal ideas and legal imagination, which is a beautiful concept, but it's also in its systemic aspects that create a political economy.
Sure. And Sergio is the expert. I mean, he's like the leading scholar on that kind of side of the argument.
Well, I wouldn't say that, but I'm very generous of you. And maybe we go with you.
Largely follow up to the question I asked earlier, but much as well with what Andy and Sector said. But if the issues are in the interpretation of fair and equitable treatment or with indirect expropriation and the backgrounds of arbitrators, et cetera, that's so complex, I would agree with you that it is essential or perhaps very useful to have some sort of holistic approach, like a WTO approach. But I'm gonna ask you to look in your crystal ball, and I apologize for that. But WTO, there hasn't been much movement or any sort of real change. Do you feel that investment law and trade law are different enough in a meaningful way to enable such discussion and creation of a holistic institution, or is this just something that we can speak about in the abstract?
Pretty much in the abstract. I don't think there is appetite for a new international organization or anything at the moment. But then as a scholar, what am I supposed to say? To say, I guess you start. This is, I think, the way it should work. Like we sit together with the different interests, and we have a purpose for the organization. I find it. So is the purpose of international investment law today sustainable development? I think it's really difficult to say that. There's pretty much nothing about it. Now, somebody could say it's not the purpose of the WTO, but there is more in the WTO. There is more food for the appellate body to bring that into a decision. There's more in the communities. There are more in the way it could work ideally. I think ISDS at its best would still have all these problems. The WTO at its best would be much different. So at least, potentially speaking, yeah, you would like to have an institution like that. Let me add to that. I mean, a lot of people who don't like this regime would like to get rid of it and go back to the idea that you have like domestic law, courts decide, and that's it. You go and invest in the US, you are a Chilean investor, then good luck with the US Supreme Court. Maybe it's good, maybe it's bad, but that's what you get when you invest in the US. I have to say that I'm not sure. I do think that international law needs to be involved. I think that the stakes are high. I think that otherwise, it might end up being about just power and diplomacy. I do think international law needs to play a role. So I'm not the ones who say like completely forget about international investment law. I do think you need something. And there I'm closer than more like in Latin America with people from CEPA, who they were not against foreign investment. And they were saying, actually, we need to to be sure as receiving countries, what kind of investment we need to attract in our country. Because if you attract investment that is really bad for your country, you are also to blame. These politicians, these ministers, the ministers that are mining or whatever, if they bring the wrong investment, then that's bad too. So we are all responsible in a way. Maybe you want to have also minimum standards, not only to protect investors, but also for what is to be an investor, So how sustainable they need to be if they want their affording protection. All these questions are very difficult to have under the current regime. But I think are questions that at least we should be talking about. And we can, because as Sergio said, the political economy of the regime is a different one. So this is what I mean by the legal imagination. Certain questions are made invisible. We know that they're relevant, but we're difficult to discuss them. If you read an article about this, the editor might say, well, there's no law here, it doesn't apply. So maybe the only point of the book is to change that.
Well,
to start talking about this.
certainly you wouldn't have that issue in the Journal of International Economic Law. And that's my marketing and my pitch. Thank you so much, and I let Teresa.
Well, thank you, gentlemen. This has been absolutely fascinating, both a history lesson as well as some really thoughtful questions to help us think about the future, both concretely and then in the abstract. So thanks to everyone who joined us online. Thank you, Professor Puig, for being our interlocutor today, and especially thank you to Professor Perrone, and congratulations on your book. So thank you so much.
That was good. Thanks. Oh, thank you. Thank you. Thank you. Yeah. What David